Good evening, everyone. I know people are still coming in, but we're going to go ahead and get started because we have a lot to cover this evening. I'm Kathleen Winters. I'm the Executive Director of the Northern District Historical Society. We are grateful to have all of you here, both in person and by Zoom. We know we have people all over the country who are attending virtually tonight, and we really appreciate your participation. We are grateful to our individual and law firm members for making tonight and other events like this possible. And we'd also like to thank the operations staff here at 450 Golden Gate and our wonderful Assistant Director, Alex Murray, for all of their work organizing tonight's program. Just a few reminders. If you registered for CLE credit and are here in person, please be sure to sign the CLE attendance sheet before you leave this evening. And for virtual attendees, we will note your attendance online. And then finally, if you're here in person, just please make sure you have silenced your cell phones. As you know from our speakers' biographies, we have a stellar panel for tonight's program. If I were to list all of their accomplishments, we would not have much time for the discussion, so please excuse the brevity of my introductions. First, we have our moderator, Jim Finberg. Jim is a partner at Altra Verzon in San Francisco. His practice consists primarily of representing employees in class and collective actions involving workplace discrimination and wage hour violations, and representing voters and voting rights actions. He has also handled constitutional cases involving issues under both the US and California constitutions. Jim is involved in numerous legal organizations, including Legal Aid at Work, where he serves as secretary of the board of directors. He also serves on the board of the Northern District Historical Society. Jim has worked with panelist Amy Whelan on an arbitration representing a transgender man where their client received $50,000 of damages, and the company then changed its anti-trans policies in a consent decree with the EEOC. He currently serves as co-counsel in a case with the Southern Poverty Law Center challenging a Florida statute that prevents teachers from using their preferred pronouns if they differ from their gender assigned at birth. They won summary judgment on their Title IX claim. Next, we have Elizabeth Gill, who is senior counsel at the ACLU's LGBTQ and HIV project, where she has worked since 2008. Her work focuses on advancing equality for LGBTQ people and people living with HIV through litigation, policy advocacy, and communications. Elizabeth's current cases include PFLAG v. MOOF and PFLAG v. OAG, which respectively challenged Texas state policy deeming gender-affirming care child abuse and the harassment of PFLAG by the Texas Attorney General. Prior to joining ACLU, Elizabeth clerked for the Honorable Karen Nelson Moore on the United States Court of Appeals for the Sixth Circuit. She graduated from Columbia College with a degree in philosophy and from Harvard Law School. To my immediate left, we have Pamela Karlan. Pam is the Kenneth and Harold Montgomery Professor of Public Interest Law and founder and co-director of the Supreme Court Litigation Clinic at Stanford Law School. Pam's scholarship focuses on constitutional litigation, particularly with respect to regulation of the political process and anti-discrimination law. Pam was an assistant counsel at the NAACP Legal Defense Fund from 1986 to 1988, where she focused on voting rights and employment discrimination. Since then, she has also served as a commissioner on the California Fair Political Practices Commission and as a Deputy Assistant Attorney General and later the Principal Deputy Assistant Attorney General in the Civil Rights Division of the U.S. Department of Justice. During her time in the department, Pam reviewed the voting section and appellate section. And last, next to Jim, we have Amy Whelan. Amy has been a senior staff attorney at the National Center for LGBTQ Rights since 2011 and works on NCLR's full range of litigation, policy, and public education work. Amy litigates complex civil cases around the country regarding marriage equality, employment discrimination, Title IX, family law, access to healthcare, prisoners' civil rights, the First Amendment, and other constitutional matters. Amy received her bachelor's degree from Princeton University and her JD from Northeastern University School of Law. Thank you again for being here tonight, and Jim, I'll now hand things over to you to kick us off.
There has been a lot of that. And her and there is military service and gender affirming care, passports and IDs, sports, etc. But before we get to the recent activity, and we will, let's get some historical context about where things were, let's say, starting after World War II, and what the sources of those rights were, so that we have a better understanding of the current litigation of those rights. So, Amy, why don't you kick us off? Tell us about the period from World War II to 2000.
Great. Hi, everybody. So good to be here with all of you. I think all right. So as Jim said, since this is the Historical Society, we'll start with a brief summary. In part to ground us, but also because, as they say, history repeats itself. And I think a lot of the themes and trends that we see in social and civic life come up in the courts, and I think we are here also to talk about those and see how they have differed or been the same throughout the history of this country. Similar to historical attacks on people, for instance, on gay people years ago, allegations like they're mentally ill or they're child predators or they're bad parents. We are now seeing strikingly similar rhetoric about transgender people. So looking back is a way to understand the moment we are in and hopefully provide paths forward as well. So with that, I think it's safe to say that the late 1940s and 1950s were a very dark time in this country for gay people. McCarthyism was in full force, along with the Lavender Scare, which included the purging of gay federal employees, along with folks suspected of being communists. And McCarthy's speeches during this time talked about the need to cleanse the government of communists and queers. There was also rampant police entrapment of gay men in particular, with very public arrests that were intended to ruin their personal and their professional lives. In 1952, homosexuality was classified as a severe mental disorder, which led to involuntary commitments of gay people into state hospitals and harmful practices like aversion therapies that resulted from those involuntary commitments. And then in the late 1960s and 70s, things started to change a little bit, in part because of things like the Compton's cafeteria and Stonewall riots, which really marked kind of the awakening of what we think of today as our modern LGBTQ civil rights movement. LGBTQ people stood up to police during those police raids for the first time, and later they organized and formed more established groups focused on LGBTQ rights. And there were also political gains during this time period as well, such as the election here in San Francisco of Harvey Milk as the first openly gay politician in the country. Also during this time, in 1973, the American Psychiatric Association removed homosexuality from the DSM, which removed that stigma from a lot of gay people's lives. Then in the late 1970s, we saw things like the Save Our Children campaign, which was formed in Florida to oppose the Miami county ordinance that banned discrimination based on sexual orientation in housing, employment, and public accommodations. That was infamously led by Anita Bryant, who was a celebrity singer, and she organized their campaign along with others to overturn that ordinance successfully. Their strategy was based on large part on vilifying gay people and comparing them to child molesters and murderers. Across the country, here in California, this was also the period in which John Briggs, the California state senator, proposed a law seeking to ban gay teachers from public schools, using similar rhetoric to the campaign in Florida. His organization was named California Defend Our Children. But unlike Bryant's success repealing the Miami ordinance, the Briggs initiative failed. And that was in part because of prominent politicians at that time, including Ronald Reagan, Jerry Brown, Gerald Ford, and Jimmy Carter, who came out in opposition of the bill. Then, of course, came the AIDS epidemic in the 1980s, and the federal government's widespread silence and inaction as thousands of people died. This resulted again, however, in more organizing by LGBTQ people in their communities to take on the care of their sick friends and neighbors at a time when governmental resources and institutions were turning their backs. An important legal case about gay people also happened during this time that was undoubtedly influenced by the AIDS crisis. So the Supreme Court issued its decision in Bowers versus Hardwick in 1986, which upheld state sodomy laws based on a ruling that prescriptions against same-sex intimate relations had quote-unquote ancient roots in our country. So in 1982, Michael Hardwick, who became the plaintiff in that case, was charged with violating a Georgia statute that criminalized sodomy after police entered his private home with an invalid warrant. The penalty for a single act was prison for up to 20 years. Hardwick challenged the law as a violation of privacy and his fundamental rights under the 14th Amendment. And in a 5-4 decision, which repeatedly referred to Hardwick as a quote-unquote practicing homosexual, the court held that Georgia's statute was constitutional, writing that, quote, there is no such thing as a fundamental right to commit homosexual sodomy. And this way of framing legal questions and how it looks at the plaintiffs in the case is, I think, going to come up again during our discussion today. The court went on to say that laws against homosexual conduct have ancient roots, and the court reasoned, therefore, that this could not be implicit in the concept of liberty or deeply rooted in this nation's history and tradition. So the court's openly hostile decision in Bowers deeply influenced LGBTQ life for 2 decades until the Supreme Court overturned that decision in a case that Pam will talk about shortly. This loss, like the cafeteria and the Stonewall riots, also though mobilized the community into action. Meanwhile, civil rights attorneys were seeing big sex discrimination wins on behalf of both women and men in the courts spanning the late 1970s into the 1990s, and of course overlapping with Justice Ginsburg's legal career. These included rulings during those 3 decades recognizing that mandatory maternity leave policies were illegal, that sexual harassment was a form of sex discrimination, that sex could not be used to dismiss jurors, and that women could not be denied admission to military academies. A couple of these cases later tied directly into decisions impacting LGBTQ plaintiffs, so I'm just going to spend a second to talk about 2 examples of those. The first is Price Waterhouse versus Hopkins, which is a Supreme Court case from 1989, in which the court recognized that sex stereotyping is also a form of sex discrimination under Title VII. They ruled that Price Waterhouse violated Title VII when it denied Ann Hopkins a promotion to partner because she didn't have stereotypically feminine character traits. So the person responsible for that hiring decision suggested that Hopkins, quote, walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hairstyled, and wear jewelry. And the Supreme Court in its ruling said, we are beyond the day when an employer could evaluate employees by assuming or insisting that they matched the stereotype associated with their group. And this case was actually litigated. We used this theory in a case that Jim and I litigated, and also Casey, who I see who just came in to the back of the room. We had a client who was fired from his job at a bank for as soon as the employer found out that he was transgender. There was no dispute that that was exactly why he was fired. We brought a case for him, which went to arbitration, and we argued successfully on his behalf that that was a violation of Title VII because that was discriminatory sex stereotyping in violation of Supreme Court precedent. So that case happened before the Bostock decision, which Pam, I think we'll also discuss. So it was during a time period where, that legal argument was very important because it had not yet been established by another Supreme Court decision that discriminating against people based on sexual orientation or the fact that they're transgender violates Title VII. Another quick example is On Call versus Sundown Onshore, which is a Supreme Court decision issued in 1998, in which the Supreme Court recognized that same-sex discrimination also violates Title VII. So Joseph On Call worked on an oil platform as part of an 8-man crew, and he was subjected by his coworkers to extreme and constant sex-related humiliating actions, including being threatened by them with rape. So the Supreme Court held that harassment by a person of the same sex can also be sex discrimination, even though that was not contemplated when Congress passed Title VII. Justice Scalia's opinion stated in a quote that's often cited these days that statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. We also saw important decisions during this time period protecting contraception and access to abortion. Now, the LGBTQ specific successes took a bit longer and certainly built off of these legal decisions and the social issues that were happening, progress that was happening at the time. And they started to match each other, arguably. So one example of that is that in 1986, there was a crucial shift in the Supreme Court in the decision of Romer versus Evans. In that case, Christian conservatives in Colorado passed a statewide constitutional amendment through a ballot initiative that prevented state or local governments from recognizing gay people as a protected class. They did this in response to cities like Aspen, Boulder, and Denver, who had recently passed city non-discrimination ordinances that protected people based on sexual orientation. So Colorado argued that the amendment simply prevented gay people from acquiring special rights. But in a 6-3 decision, the U.S. Supreme Court ruled that the state statute violated the Equal Protection Clause, holding that the U.S. Constitution does not permit, quote, laws of this sort. They raise the inevitable inference that the disadvantage imposed is born of animosity toward the class of persons affected. If equal protection of the laws means anything, it must, at the very least, mean that a bare desire to harm a politically unpopular group cannot constitute a legitimate government interest. So with that lightning quick overview, I'm gonna hand this off to Pam to talk about the significant progress in the LGBTQ movement over the next 2 decades. But we'll hopefully also talk more about the connection between social and legal progress that we are seeing here, the effects that even legal losses have on civil rights movements, and how the Romer decision impacted later onslaughts of anti-LGBTQ legislation, including in this moment where we are experiencing that right now.
So Amy, was Romer decided under a rational basis?
Romer was decided under rational basis and was sort of the birth of this animus test, which many legal cases and lawyers have continued to make arguments based on animus in subsequent cases before the court. But yes, and so it is one of the first cases in which, even under rational basis review, a law was struck down.
So Pam, as Amy pointed out, in 2003, the Supreme Court strikes down the Bowers rule 17 years earlier. What happened in those 17 years that inside that?
Well, it's great to be here. I think I can give you what happened in the courtroom and then tie it to what happened out in the world. So in 1986, when the Supreme Court decided Bowers against Hardwick, originally the court voted 5-4 to strike down the Georgia statute, but then Justice Lewis Powell switched his vote to uphold the statute. And at the conference, when the justices meet, and it's just the justices in the room, we know from the notes taken by several of the justices that have now been released, that Justice Powell said that he didn't think he'd ever met anyone who was gay. And of course he had. Indeed, that very year, one of his 4 clerks was gay, and one of his secretaries was lesbian, but he didn't know that. Right? So it was an unknown unknowns. If you move forward to the Supreme Court's decision in Lawrence, the person who argued Lawrence on behalf of the 2 men who had been arrested was Paul Smith, who was a former law clerk to Justice Powell, who was himself gay and was openly gay at the time that he argued Lawrence, as opposed to how he had been in the closet when he was working with Justice. And I was in the courtroom for the argument in Lawrence, and I think most of the gay, lesbian, bisexual clerks in the history of the Supreme Court were there to watch the argument. And you could see, as the justices came out from behind the curtain to walk into, you could see Justice O'Connor, and she was looking down the row and going, and I think that made a huge difference to the justices, because the justices find it much easier to empathize with the claims of people that they know and they like and they respect. And so one of the big drivers of the change at the Supreme Court from Bowers to Lawrence was the fact that people came out, and the justices knew that. And they could no longer assume, as Justice Powell did at the argument in Bowers, Justice Powell at the argument in Bowers was asking especially about, like, well, if we decriminalize, gay sex, what's going to happen in, like, bathrooms and gas stations? And nobody would ask that question today, right? That just wouldn't be the kind of question that's asked. So that's a huge difference. What was interesting doctrinally in Lawrence is that the court had both kind of substantive due process rationale, that the decision about how to live your intimate life, that kind of personal decision making, is part of what's central to the liberty that the due process clause protects. So in that sense, it tied in, as Amy was saying, to other decisional autonomy cases, like the abortion cases and like child raising cases and like. But there was also this equal protection kind of overlay. So, for example, for Justice Kennedy himself, he says, that gay people should have the same right to make these decisions. They have to seek autonomy just as heterosexual persons do. So that's an equal protection sounding argument. And Justice O'Connor, who had to switch her vote, she had voted to uphold the statute in Bowers and voted to strike down the Texas statute in Lawrence, explicitly said the problem here is equal protection. You cannot treat the decisions that gay people make differently from the decisions that straight people make. And so that had a huge effect on this kind of decision about keeping the government out of gay people's lives. But of course, there are two kinds of freedoms. There are the freedom from, that is, keeping the government out of your bedroom, out of your decisions about how you organize your life. But there's also a kind of freedom to, an affirmative liberty claim, which is to respect for and protection of people's relationships by the government. That is, it's one thing to say, we don't think that private consensual adult sexual activity should be made a crime. It's another thing entirely to say the government has to provide affirmative support for people's relationships. When I sort of talk about this, sometimes I say, everybody has a right to marriage, but if you can't find anybody who will marry you, the government doesn't have to provide somebody, right? I mean, it's not like the government has to provide. So the next round of cases, though, were about recognition for gay people's relationships. And these come to be the marriage cases. They were litigated originally in state courts. It was like many other civil rights movements, most notably the movement that led to Brown against Board of Education, a decades-long movement that thought about moving in incremental steps. So the first rounds of cases were about things like survivors' benefits. If you've ever lived in New York, the most important thing in New York is your control of a rent-controlled apartment. So does the surviving partner of somebody get to keep the apartment or the like? There were cases about protection of people's relationships with their children and the like, and then came the registered domestic partner cases. That is, the government has to give some kind of protection to gay people's rights. These were brought in states that were sympathetic, politically sympathetic, so you didn't see cases being brought for the most part in places like Alabama and the like. And ultimately, this culminated in a series of marriage cases that went to the Supreme Court. I just want to identify three of them and talk very briefly about kind of what they tell us about strategy and what they tell us about doctrine. So the first of these cases was Windsor against the United States, which is a case that struck down the Federal Defense of Marriage Act, which was a backlash to the prospect of marriage equality. Congress passed a law defining marriage in the Dictionary Act as between one man and one woman for purposes of all federal laws. And there are about 1,100 federal laws that turn on marriage in one way or another. The Supreme Court struck this down in the Windsor case. I have the privilege of helping to represent Judy Windsor. And one of the things that was, I think, helpful about the case when it got to the Supreme Court is who the plaintiff was. That is, it was an elderly woman who had a long-standing relationship. When her partner died after they had been together for 40 years, they had gotten married in Canada as her partner was dying. They got socked with a $367,000 estate tax bill. So, you might think, is the most sympathetic case a rich person suing to get their taxes back from the government? But if you think of who's on the Supreme Court, that's not the worst case in the world. And if you want to just see one other thing, these cases can take a long time to litigate. And so a case on behalf of someone who is the surviving spouse has the advantage you don't have to worry that there will be a breakup during the case, which could also be problematic. So the Supreme Court decided that case, and at the same time that they had that case in front of them, they had the California marriage case in front of them. And the court punted on that. And I think in 2013, the court wasn't quite ready yet to say that every state had to provide marriage equality. And I think one of the really brilliant things that Judge Walker did, and you can see his portrait over there, was he insisted on there being a trial in the California marriage case about whether California actually had any basis, any legitimate basis for restricting marriage to opposite sex couples. And up until now, people had just kind of assumed the arguments on both sides. There was never any attempt to actually try them in court and have findings of fact and conclusions of law. And one of the interesting things is just how much the arguments against marriage equality evaporated once they were subjected to actual adversarial testing in a courtroom where somebody had to put people on the stand to testify under oath. Because if you look back at, for example, the New York Court of Appeals case that had upheld New York's refusal to allow same-sex marriage, although they recognized same-sex marriages that were conducted elsewhere. One of the things that was most amazing to me there is, and we'll see this play out in some of the transgender rights cases that we're going to be talking about in a moment, is the sheer lunacy of some of the arguments. So the argument in New York for why you could restrict marriage to opposite sex couples is same-sex couples do not have children by accident. Opposite sex couples do. And so if you want to make sure that men will stick around to take care of their children, you have to have this institution that binds them to the children and the other parent. And so what you saw there was this weird flip from the problem is gay people are so immoral that we shouldn't give them access to this wonderful institution of marriage to, no, straight men are so feckless and immoral that they're the only people that we should care about in marriage. And those kinds of arguments are looming arguments, and you'll see those same kinds of arguments being made in some of the transgender rights cases as well. So ultimately, the Supreme Court in 2015 recognized a nationwide entitlement to have same-sex couples treated exactly the same as opposite-sex couples when it comes to marriage. So no, you cannot marry two people. No, you cannot marry your 12-year-old, a 12-year-old. No, you cannot marry your niece. But as long as you're both adults who are not married to somebody else who compass ventus, you can get married. As Mae West said, marriage is a wonderful institution, but I'm not ready to put it in an institution yet. The last of the cases I wanted to talk about is Bostock against Harris Funeral, Bostock against Clayton County and Harris Funeral Homes against Stevens. These were a pair of cases that were argued at the Supreme Court together about Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination because of sex. And the question was, what does because of sex mean? And here I'm going to tie back to something Amy said about the Uncalcate, which is if you asked in 1964, when Title VII was enacted, did Congress think it was protecting gay workers, lesbian workers, transgender workers? That question is no. They didn't think about that at all. In a majority of states, at least male homosexual activity was still outlawed. But the word they used, sex, in 1964 meant whether somebody was male or female. And I argued the gay part of the case. There was two gay men, that's Bostock and Zarda, and one transgender woman, that's Stevens, whose cases came up to the Supreme Court together. And I spent a lot of time in the basement looking at dictionaries from 1964, and they all just said it's whether you were assigned female or male. And so the arguments in the case were textual arguments. I mean, we had a great stereotyping argument of the kind of Price Waterhouse kind that Amy alluded to earlier. We had a really nice argument that this is just like Loving against Virginia, which said it's race discrimination if you don't allow interracial marriages. So it's sex discrimination if you tell somebody you can only marry people of a particular sex. We had also an argument based on an old Supreme Court case called Martin Marietta, which was about you couldn't discriminate against women with children. That was a form of sex discrimination. So even if you hired lots of women, if you wouldn't hire women with children, but you'd hire men with children, that was sex discrimination. And we said, if you hire a woman with a husband, but not a man with a husband, that's sex discrimination in the same way. But it was pretty clear after I got up to do the arguments in Boston, and I was arguing, and then David Cole, who's a colleague of Elizabeth's, was arguing right after me, in the Amy Stevens case. It was pretty clear to me after about a minute and a half of the argument that all they wanted to talk about was the text. And so I just kept saying, you know, man with a husband gets fired, woman with a husband doesn't. That's sex discrimination. And the court bought the argument. Justice Gorsuch's opinion for the court, which was 6-3, bought the argument that this was text and this was just a straightforward piece of text. And when I think about like why did the court buy the argument, the cynical part of me says because it wasn't that costly. It allowed the members of the court who purport to be textualists to say, see, here's a principled application of textualism to something that if we were making a policy, we might not be prepared to do. But text allows us to get there. And then the second thing about it is, although a majority of American workers are protected by Title VII, a majority of American employers are not. That's because Title VII only covers employers who have more than 15 full-time employees. Now, you know, obviously, companies like Walmart, the federal government, state, local governments, they all have enough employees. But a majority of American employers are actually small businesses. And so this was a relatively costless way to show principle because the people who object the most to fair employment practices are small employers. They're not large corporations. Indeed, we had amicus briefs from almost every large corporation saying, we're in favor of fair employment. We don't discriminate on these grounds. And so I think the history from 1986 forward to 2020 is one in which the increased visibility of gay people, the increased visibility and relationship. I mean, nobody wakes up and discovers one day that their kid is undocumented. But people wake up every day and discover that their kids are gay, or lesbian, or transgender, or bisexual, and that changes people's behavior. And I think that's a lot of what got us to 2020, when unfortunately things begin to turn around.
So Elizabeth, we've heard a lot about the Supreme Court. Tell us about what's going on with regulations, the EEOC, and executive orders.
So going back a little bit, Pam ended in 2020, but in terms of federal agency action, going back to 2008, the Obama administration, so 2008 to 2016, were really a wonderful time to be working in the LGBTQ movement. And we saw so much progress in that era. The Obama administration is really the first administration to have high profile nominees be out gay and lesbian. So EOC commissioner, for example, you know, an out lesbian. And that's really important, as Pam says. And so prior to Vostok then, there's a lot of federal agency action in this era that expands non-discrimination protections for LGBTQ folks. And the language of that was at the time, and continues to be in many state statutes and first decisions, sexual orientation and gender identity. As our work on transgender rights has evolved, you know, we think of gender identity as being a more complicated frame now than it was then. But at the time, the sort of non-discrimination protections rolled out, and the language was sexual orientation and gender identity. So the EOC in 2012, even before sexual orientation, found that Title VII protected workers from discrimination based on gender identity in the Macy case. The same went for sexual orientation in the Baldwin case in 2015. And then also in 2015, the EEOC found that denying a transgender employee access to a restroom based on that aligned with their gender identity also violated. So you have this this wave of really positive decisions coming out of the EOC and in other agencies as well. There wasn't an effort that was coordinated by the Environment Nutrition necessarily, but in a number of the individual agencies, you saw push out of interpretation of Title IX that it protected young people from discrimination based on sexual orientation or gender identity, or in housing, or in healthcare. In 2016, HHS issued regulations under the Affordable Care Act prohibiting gender identity discrimination in healthcare, which is perceived in many ways to be costly. So it is in the healthcare space that I think we see a significant amount of the backlash that we are experiencing today, and where progress is particularly important because healthcare is a necessary aspect of access to healthcare is a necessary aspect of being transgender. In that same era, DOJ litigated transgender discrimination cases with us. You have from the administration both in terms of executive action and enforcement. In 2016, North Carolina passed a law that was a statewide facilities ban. So meaning the law said that folks had to use restrooms that were correlated to their sex assigned at birth. So excluding trans folks from access to appropriate restrooms. There was a national outcry about this law. I was part of the litigation team from the ACLU that sued. It was a wildly different climate than where we are now. There was enormous economic pressure put on North Carolina to rescind the law. The Obama era DOJ joined with us in suing the state of North Carolina over that bill. We didn't progress very far because in 2016, the times changed, but it was remarkable that was where we were at that time. When the first Trump administration came into power in 2017, they did take steps to walk back a number of the agency actions that had been extended to, again, protect transgender people, to take the court's ruling in well, that comes there. To walk back agency actions that prohibited discrimination based on sexual orientation and gender identity. But they didn't really do more than that. They just walked back the extensions of the protections. They didn't do what they're doing now, which is pushing out openly discriminatory policies under the guise of enforcing existing civil rights frameworks. So entering office in 2021, 6 months after the court's decision in Bostock, President Biden issued a series of executive orders directing federal agencies to apply Bostock in every area of federal law. So expanding the ruling that applied to Title VII to the other civil rights acts, to housing, to schools. And agencies took prompt action, extending the force of Bostock to all these other arenas. Biden also issued an executive order permitting openly transgender folks to serve in the U.S. openly in the U.S. military, which was countering a Trump era policy of excluding trans folks from military service. And then in 2022, President Biden issued an executive order expanding gender markers on passports, which is an important expansion to not just being able to change your gender marker from NDAF or vice versa, but permitting X-gender markers on passports. Beginning in 2027, so those were the good times. 2008 to 2016 were the good years, and there was a window in the Biden administration where we saw, really positive executive actions from the federal government. Beginning in 2017, though, there started to be a real backlash to the successes of our movement in expanding non-discrimination protections, particularly for transgender folks. So starting again in 2027, conservative states more aggressively started passing laws explicitly restricting the rights of transgender people. The ACLU started a national tracker for explicitly anti-LGBT legislation in 2008. And since then, have tracked, hundreds and hundreds of bills annually that are openly targeted at limiting the rights of LGBTQ people, but mostly trans people. And trans folks in the United States are about 1% of the population. We're really not talking about an enormous population of people. And yet, in the past almost 10 now years, every single year sees in conservative state legislatures multiple bills that are, banning trans folks from accessing facilities that align with their gender identity, bans on healthcare for transgender people, particularly transgender youth, bans on healthcare for transgender folks in prisons and jail, bans on funding for anyone for healthcare, young people and adults, book bans, curriculum bans, sports bans, don't say gay law, drag bans, which echo the history of anti-trans legislation in terms of all of the historical bans and cross-dressing, and restrictive ID laws. This year alone, over 500 bills have been introduced in state legislatures, again, explicitly targeting LGBTQ people. And I'll just note that the rhetoric in these state legislatures is just a mirror image of the historical rhetoric against gay people. That they, folks are talking about predators, they're talking about harming children, they're talking about, that it's inherently fraudulent to be a transgender person. And that's, that there's fear, profound fear, and the rhetoric is just really openly hostile and results in openly hostile laws. In 2025, the second Trump administration, following the recommendations Project 2025, made rolling back LGBTQ rights a priority, and specifically focused on eliminating what they refer to as gender ideology, which means rejecting the existence of transgender people. So day one of the Trump administration, he issued an executive order defining sex to be essentially what you were assigned at birth, and therefore you, under this executive order, status as a transgender person does not exist. He then ordered all the agencies to apply this policy, and they are in the process of doing that. In that, they're inverting the way that the civil rights laws have been interpreted historically by agencies and by courts. So it's not just the policy of this administration that transgender people shouldn't be protected by Title VII, for example. It's the policy of this administration that Title VII requires discrimination against transgender people, that it violates the rights of women in the workplace for transgender women to be included in facilities access, in other non-discrimination protections. And they have also prioritized enforcement in this arena. So the Department of Justice, all the other federal enforcement agencies have declared as priorities focusing on, in particular, implementing this gender ideology EO, which again is about rejecting the very concept of transgender people, and are using that nationwide to attack, school districts, inclusive school districts, healthcare providers that provide healthcare for transgender people, and not just in conservative states. So, states where our laws and constitutions, like California, have explicit protections for transgender folks, that those states have been the target of the Trump administration in saying that, for example, inclusive school policies violate Title IX. And so with that, I will hand it over to Amy to talk about the military.
And with that historical context, we're going into a lightning round, topic by topic, starting with military service.
Yes, okay, but let's have a warning here that this is not the happy part of this discussion, although I will say
Each of our panelists have had significant victories.
and not just us. I mean, really, truly, as a lawyer and a civil rights lawyer during this time, there is an incredible amount of litigation happening now. There are literally hundreds of cases pending around the country, some in this very court, that challenge myriad policies by this administration. And there are people who have deep knowledge of our government and our institutions who are litigating those cases. So I just, I have to say, this is a moment in time where lawyers are really pulling our weight. And it is a time when the other two branches of government are not pulling their weight. And so this is an incredibly important historical moment for our courts and for lawyers and for upholding the rule of law. And we're about to start to talk about cases where we see a massive denigration of constitutional concepts and doctrine that we've set forth and sort of previewed in some of these cases that just gets sort of thrown by the wayside. And so I will very briefly talk about the Trump administration ban on transgender service members, because it is something he did in his first term, and that NCLR challenged along with other Lambda Legal and other national groups. And then it was undone during the Biden administration. And then the moment Trump came into office again, he immediately tried to ban transgender service members again. And as Elizabeth is talking about, this really is an employment issue. The United States military is the largest employer in certainly this country, maybe in the world. And so we knew that if you are going to have a policy that transgender people are per se unqualified employees, that is an extremely dangerous precedent to establish for any employee. That simply a characteristic of them, that somebody based on who they are could be just deemed unfit to be an employee in this country. I don't even, it's sort of overwhelming to think that our federal government has that position, but they do. So we immediately challenged that law. We won a preliminary injunction on behalf of several longstanding service members who collectively have served in the military for more than 100 years in this country. And this is an example when the Supreme Court on its shadow docket basically stayed our preliminary injunction and said that they were going to allow these separations of military transgender service members to happen while the case is being litigated. That was a very surprising and deeply disturbing action, and one of many actions on the shadow docket that the Supreme Court has taken. So we are still litigating our case. The government's appeal of the preliminary injunction was argued in the DC Circuit in January and is still pending. And meanwhile, we have moved forward with moving for class certification on behalf of our plaintiffs. And at the same time, though, our plaintiffs and others are starting to receive notices of separation proceedings to try to remove them from the military. Lambda Legal also has a case that is proceeding in discovery, and the government's appeal of their preliminary injunction was argued in the Ninth Circuit in October and is still pending. So that's sort of the status of those cases. They are still being litigated despite the Supreme Court allowing, in theory, these separations to happen.
So Elizabeth, you and ACLU have been active in the area of passports and ID documents. Tell us about what's going on there.
There's so many acronyms. So, on the ID documents front, and ID documents are really important for trans folks because, being able to change your gender marker allows you to live a life where you're not questioned about who you are, and having a different gender marker, having your sex assigned at birth that no longer aligns who you are, can out you as trans, can have profound harms, can just, in various contexts where there would be hostility around that. So another one of this administration's first day executive orders was unwinding the Biden administration executive order on passports and aligning passports with the gender ideology executive order. So therefore preventing trans folks from ever changing a gender marker on their passport and eliminating the abilities of anyone having an X gender marker. That executive order was prospective, and the action that the State Department took on the basis of it was also prospective. We sued in the District Court of Massachusetts, nationwide class action. Sadly, that also went up on the shadow docket and was saved by the U.S. Supreme Court using very dismissive language. So the per curiam says, displaying passport holders' sex at birth no more offends equal protection principles than displaying their country of origin. In both cases, the government is merely attesting to a historical fact without subjecting anyone to different treatment. So we are continuing to litigate that case, although the language of the curiam is proving a challenge. And I don't know if now do you want to show?
Yes, we were supposed to have a fourth panelist, Professor Alex Chen from Harvard, and I will now play a video from him explaining why he's likely.
Good evening. It's such an honor and a pleasure to be invited to address the U.S. District Court for the Northern District of California Historical Society's event today on gender identity and equal rights, past, present, and future. I regret that I am not able to join you in person, especially with such dear and respected colleagues and collaborators as the panelists that you're going to have today. But I am thrilled to be able to provide some introductory remarks. You're going to hear from those amazing folks about a lot more about the doctrine and legal landscape. And I think, I've been asked today just to share a little bit more so about my personal story. So that's what I'm going to focus on. And I think, I sometimes don't really necessarily talk about the impact these kinds of things have on my personal life, but I'll share here that one of the reasons that I can't be with you all today is because, as a transgender person, one of the things that's impacting my life is the fact that the United States Supreme Court vacated the preliminary injunction that was issued by a district court in the Trump versus Orr case involving the State Department's policy of refusing to issue transgender people with passports that reflect their gender identity rather than sex assigned at birth, which unfortunately has the personal impact for me and my fiance that it will not be safe for us to leave the country together past a certain point this year, right? And unfortunately, that really interferes with certain plans that we had after he and I got engaged for me to be able to bring him to China, which is where my family originally came from, and for him to meet those relatives before we get married. And in fact, that if we do not do this now, that it will be the earliest January 2029 before there's even a possibility of a reversal of this passport policy, it seems, based on the way things are currently going, although knock on wood, maybe I'm being unduly pessimistic. But if not, that's the soonest that would happen. And by that time, there are numerous people over there that might not survive to see that day, right? And so I think just that small vignette to say, I am, one of the most privileged and powerful and safe transgender people in the country in some ways relative to many other people in this community. And even I am starting to feel directly the impact of some of these policy changes on my own life.
Close out the ID discussion. We're already starting to see state laws going a step further with ID documents. Kansas just passed a law this year that immediately invalidates all state issued driver's licenses with a changed gender marker. We filed in state court, and that law also imposes criminal penalties on a facilities ban. We filed a lawsuit earlier this year. It sought a TRO, was denied. So that law is in effect. We are in the process of seeking a preliminary injunction, the hearing in September. But in places where you need to drive a car, which is a lot of the United States, having a valid driver's license that doesn't reflect who you are today puts folks at enormous risk. I will close out the ID section by saying we had a big win in Montana State Court last week, the Montana Supreme Court, in the ACLU's challenge to Montana ID law, upheld an injunction from the lower court against that law, and has wonderful language about the importance of IDs in people's day-to-day lives, and also finds that under the Montana Constitution, transgender status is a separate class for which purposes of equal protection.
So let's turn to gender affirming care. There's been a lot of activity there. Amy, you and NCLR have a case about that. Tell us about what's going on.
Yeah, I mean, I would say that, healthcare and healthcare issues are taking up for sure most of my time right now. And really, I think what is happening in terms of the Trump administration actions attacking this medically necessary care for transgender people, it really started at the state level, and it started really more like 2017 during the time period that Elizabeth was outlining an utter rash of laws that mostly red states were passing that were attempting to ban gender affirming care for minors in those states. And those laws we were litigating against for several years, challenging them and mostly winning in the lower courts on those cases. And I think Jan will talk about then what happened when they went to the Supreme Court. But we were chalking up many, many victories in those cases before that happened. So this is one part of that I think reminds me of what was happening before. You know, we talked about the ordinances with John Briggs and Anita Bryant, and here again, there's a rash of laws attacking this basic health care that transgender people need. And what are we going to see in response to that in this country is sort of up to be seen. But I would tell you that a lot of my time is spent talking to families and hearing from these children and trying to guide them into these crises that this has thrown their lives into. I mean, these children sometimes, this healthcare has made the difference between these parents having a kid who is healthy and social and thriving in school, and a kid who literally one of two of the parents had to sleep on this kid's floor every night, this child, to like help them go to sleep. So these issues are incredibly impactful on these people's lives. And as Elizabeth said, we're talking about a tiny population of children that is being targeted and attacked by this administration. And so I don't think it makes sense to outline the parade of attacks that are happening from this administration, but maybe Pam will talk about the Skrmetti decision because it's important in terms of doctrine and also where we are today with these issues.
Sure. So the Skrmetti case involved a ban, actually two bans, one in Tennessee and one in Kentucky, of gender affirming care for minors. The issue that went up to the Supreme Court was entirely about puberty blockers and cross-sex hormones. And one of the things that's striking about the case, and this will tie back in again to things Amy was talking about earlier, is the relationship between equal protection and substantive due process. And so there were two lawsuits at issue here. One lawsuit was brought by the parents of transgender kids seeking to be allowed to continue gender affirming care for their kids. The other was brought by the United States during the Biden administration. And the thing to understand here is the United States only has litigating authority to bring equal protection claims. It doesn't have litigating authority to claim that a law violates substantive due process. And so in the lower courts, both the United States and the parents were suing. The parents were claiming both the equal protection rights and they were claiming substantive due process rights in their ability to control the upbringing of their children, which is a series of cases that go back to the 1920s and the right to send your kid to private school or to send your kid to a school in which they teach German. And and the like, right? So there are two different kinds of claims. The Sixth Circuit decided in favor of the Tennessee and Kentucky laws, and both the United States and the parents petitioned the Supreme Court for certiorari. The Supreme Court granted only the United States system, which meant that only the equal protection claim was in front of the court, and not the substantive due process right of the parents to make medical decisions for their children. Now, why is this important? It's because the court didn't want to take the substantive due process issue, because at the very same time that they were taking this case, the case about gender affirming care for minors, they were taking a case called Mahmoud against Taylor, which involved the rights of parents who object on religious grounds to the portrayal of LGBT people. They were taking a case by involving those parents asking to be allowed to remove their children from classrooms anytime that a book that celebrated LGBT folks was being read during story hour. And it would have been an extraordinarily bad look for the Supreme Court to be saying simultaneously, this group of parents, we're going to protect their decisions about how to raise their children. This group of parents, we aren't. So they didn't take the substantive due process. And I'm convinced that that's in part a strategic move by the Supreme Court to avoid looking like hypocrites. So they took the equal protection claim, and you might think that having decided in Bostock that just refusing to give somebody a job because they were transgender is a form of sex discrimination, that the court would have to say here that refusing to allow the use of puberty blockers for a kid who's transgender, when you don't forbid the use of those same puberty blockers for a kid who's going through precocious puberty, or refusing to give cross-sex hormones to a transgender kid when you will give those hormones to a cisgender kid who has a condition that they're indicated for, you might think that would be sex discrimination. This woman said, no. This is just discrimination on the basis of medical condition. It's not discrimination on the basis of sex, which is a very, I think, very strained reading, because you will allow the same treatment if it confirms the gender identity of a child as being the sex assigned at birth, but not if it doesn't confirm that. But in any event, the Supreme Court upheld the Tennessee and Kentucky laws, and you're seeing just a raft of cases now where that plays out. So, for example, in cases about funding and executive order, the Fourth Circuit recently said, well, we have to reconsider what we did before because of the Scrivetti. And so Scrivetti is having these kind of knock-on effects on things like executive orders, funding for healthcare, and the like. And so the Fourth Circuit just upheld a decision that West Virginia can ban payment for gender-affirming care through its Medicaid system.
So it seems like there's a difference between gender-affirming care for minor cases and gender-affirming care for adults and for prisoners. Elizabeth, can you tell us how?
Right, I know, as Pam said, the panel on the Fourth Circuit just applies to many to adults. So, that window may be quickly closing. Yes, the Trump administration has also pushed out policies that prevent trans folks in federal carceral settings, prisons, and immigration detention from getting gender-affirming care and requiring them to be housed in prison or detention center of their sex assigned at birth. And this has been a historical area of focus for the ACLU and other orgs, just because transgender folks in carceral settings are particularly vulnerable, especially transgender women. An important case was litigated in this district court, finding a denial of care for a trans prisoner in prison here to be unconstitutional. And so we have long litigated those cases under the Eighth Amendment and sometimes the Rehabilitation Act. Where we are, there's litigation in process. we are seeking a certification of a nationwide class action. I think, given the limitations on access to healthcare for young people, those are hard arguments even in these other contexts. And we will see increasing restrictions on adult healthcare in other states. So West Virginia's Medicaid ban was upheld. A number of other states also have those bans. And again, in these conservative states, we are seeing them starting to reach adult healthcare even outside of context.
We're running out of time, but we've got two more. Let's see if we can cover two more topics: sports and schools. Easy peasy. Amy, tell us about sports.
That's not me.
No, okay.
Understand that?
Pam, you want to talk about West Virginia?
Yeah,
versus-
so,
Okay.
Title IX of the Education Amendments of 1972 is designed to ensure various forms of gender equity in educational institutions that receive federal funds. So basically every public school system in the country and all but about 3 institutions of higher learning in the United States. Everybody else is covered. And Title IX, if you think about it, has had incredible effects on the opportunities of girls and women for playing sports. If you go back to when I was in high school, when I was in middle school, girls still played 6-on-6 basketball where you couldn't cross the center line. 3 of the girls were on one side, 3 of the girls on the other side, and you passed the ball. There were no varsity sports for girls at lots of high schools, or there'd be like 1 or 2 sports, and the boys had all sorts. And so Title IX really transformed women's sports in the United States. There's no doubt about that. There's also no doubt about the fact that when you get to high levels of competition, for many sports, men and women are different. If you had 2 basketball teams at your school, if it was a university, and there were 15 people on each team, and there was not a women's basketball team and a men's basketball team, you would have 2 teams made up of 15 men. And again, there's no real controversy about that. The question that's raised in the Title IX cases that are now working their way through the system, though, is what do you do about transgender kids? And here, I think it's important to say 2 things. The first is the extent to which, and it's been, I think, implicit in all of our discussions so far, that this is tied in with gender issues about women. It's not primarily about can transgender boys play on boys' teams. It's about whether transgender girls can play on girls' teams, because there is this notion that transgender girls and transgender women are not really girls and women. And it's focused, I think, almost entirely on that. That is, I've never seen, Gavin Wren's case is really one of only about 2 cases I can think of that involve transgender boys or transgender men. Almost everything else in these denial of access to facilities cases involves girls. And BJP, I can get her mixed up with the fascist party in India, because I can't remember which one's which. But BPJ is a transgender girl who, at the time the lawsuit began, she was about 11 years old, and she wanted to participate on her middle school's no-cut cross-country team. And she was also remarkably slow in addition to everything else. So she never won a race. She was always, like 25th. And then West Virginia passed a law that banned transgender girls from participating on girls' teams. She brought a lawsuit about this. And the 4th Circuit held that it violated Title IX for her to be denied access to the team. At the same time, there was a case coming out of Idaho, a case called Little against Peacocks, that involved a transgender woman who wanted to participate on a team at the University of Idaho. Was it Boise State or Idaho? It was University of Idaho. But in any event, that case went off on equal protection grounds in the Ninth Circuit, which held that she had the right to participate. Now, again, looking at how the Supreme Court treats these cases, by the time the Little against Peacock's case got to the Supreme Court, Lizzie Peacock decided she didn't want to participate in sports anymore and suggested they get rid of the case on mootness grounds. And oddly, the Supreme Court just like kept the case in there so they could just keep kind of punching at it. Because I think the arguments that the court, what the court is thinking in its head is this is all about varsity athletics at high levels of competition and not about what 90% of sports and Title IX are about, which is allowing everybody to participate because of the educational benefits of participation. And so the argument did not go well, I think it's safe to say, at the Supreme Court, not because the lawyers did a bad job, the lawyers did a phenomenal job, but because the Supreme Court is fundamentally unsympathetic to the claims of transgender people now. And it will be, again, very interesting to see how the court wheels out of the fact that they said the words because of sex meant in Title VII transgender status, and the same words were used in 1972, both in Title IX and in the 1972 amendments to Title VII, which also lost sex.
All right, schools. The Trump administration executive order asked the Department of Education to withhold funds from K-12 schools that allow transgender students to use school facilities such as restrooms or locker rooms that differ from their gender assigned at birth. Withhold funds if schools don't inform parents that the child has a gender identity that differs from gender assigned at birth, and withhold funds if the school teaches gender identity. Amy, what's going on in this case?
Yeah, well, although Jim, maybe you want to talk about your case also,
Well,
this section.
well, that's one of our audience members, since Mr. Boyd argued this issue, and you want to stand up and tell us about Wood?
We're going to give you a night the people who are
Do you want to, we're gonna put, we don't know, we might put someone else on the spot.
we're just going to start the whole call now.
Right, it's a product method from now on.
You look like somebody that might have.
Step right up.
So Woodbridge, Florida, is a case we brought on behalf of two transgender teachers in Florida, challenging the Florida laws that prohibits them from using their titles or pronouns with students. They can actually use any other transgender person's preferred titles, pronouns, including their students, but they just can't share them at home. So we challenged that under both Title VII and the First Amendment. One PI stage of the First Amendment, basically using the logic of a case called Kennedy, the Supreme Court said that a teacher has a right to pray. That's the expression is religion to the students, but apparently it's going to the circuit, it's different when it's gender identity. And then we won in the district court on Title VII, so we're waiting for him to issue a final order to be killed.
Okay, thank you, Sam. And now, Elizabeth, do you want to tell us about that first?
Oh, I was just saying, I wanted to move to the last section.
All right, move to the last section. All right, last section. Elizabeth, jump off the last section.
Likely direction of the law's development, well, certainly in the short term, we don't see good things happening. I think, the PPJ, Peacock's decision will come out later than June of this year. And, I'll just add on to Anna's presentation that the U.S. Department of Justice is explicitly asking in that case for Title IX to be interpreted to require exclusion of trans kids from sports. So it's not just a question of does Title IX require trans kids to be included, but it is, does Title IX require exclusion? And again, that could have enormous impacts on the other civil rights laws if they go in that direction. So, we are looking at losses on a number of levels, permitting the federal government and states to openly discriminate against trans people. And, I think that we are in this moment of enormous backlash. We have been here before as a movement. I think, many of my colleagues would say we were here in the AIDS crisis when we had made progress on recognition of gay people, and then AIDS, and, treatment of folks who were living with HIV and or AIDS, really changed the inclusive policies of the era, and there's an enormous backlash, which we managed to work ourselves out of. So I'll just start off by saying that it is, I think we're looking at an era where discrimination is explicitly permitted and or required in some instances, and just have to keep pushing through to change that.
But I'm gonna add something
Yeah.
that I skipped one of my sections, which is that I do think this is though an example where there are many wins that we are getting, and it's important to keep sight of those, because not every case can go up to the shadow docket, not every case can go to the Supreme Court. And even for the prison medical care cases that Elizabeth was talking about, Trump announced those directives to stop all Medicare for all medical care for transgender federal prisoners, and to move this very tiny population of transgender women prisoners to men's facilities, women who have been placed in those women's facilities because they are at extreme risk of physical and sexual harm. And we at NCLR have some cases, the ACLU has a case, but we have succeeded in stopping those policies from going into effect, which our preliminary injunctions have been in place for now more than a year, that those federal prisoners have continued to have access to medical care, and that small subset of women have been protected and not allowed to move. So there are many, and that's just one example. There are many cases where there is progress being made, where there are wins, not just in the field of LGBTQ rights, but in other contexts too, where we are even slowing down or stopping the most dangerous of policies that are going into effect, and those are frankly wins, for as long as we can keep people protected. So,
Yeah, I mean, I think you've seen from the various kind of presentations that we've done that things go like this. And there's always been some group in America that's been the scapegoat, and that's been the group that people who want to engage in fear mongering have kind of coalesced around. And I think right now the fascinating thing to me is how much of this is just about transgender folks now. That is, there doesn't seem to be nearly as much in the way of overt discrimination on sexual orientation as there is on gender identity. And so some of this is just recognizing that these are historic patterns that have happened before, and that people have to organize and change the political process if they want to get permanent change. I mean, we were talking about this before the panel began, but I can't help but notice that today the Supreme Court gutted perhaps the most transformative law in the history of American race relations, which is the Voting Rights Act of 1965. So there is going to have to be another generation of working to kind of recapture the gains that statute allowed. And there's going to have to be the same kind of thing with regard to gender identity and the rights of transgender folks.
Do you think that the language in Strometti looking at historical rights going back to the days of Bowers, and does that have implications for taking away rights to contraception or other things? I mean, you say it's focused on transgender. Yes, they are a fixture of this administration. What are their broader concerns?
So there are a whole bunch of different anti-civil rights things, I think, kind of swirling around right now. Some of them are connected to each other. So the whole restriction on abortion rights is an attack on substantive due process, which is also the kind of medical decision making and the parental control issues that Spermetti was about. So those things are linked. I think we have right now we have a federal government that is very hostile to almost every kind of civil rights claim out there, except the claim of culturally conservative Christians. I mean, it's not, they're anti-Muslim, They're a little bit worried about the Sikhs. They don't like people from Haiti. They don't like, I mean, it's like, you know, it's like, Sam, I do not like this group. I do not like this group. I do not like this group. Not liking rights here, not liking rights there, not liking rights anywhere. So, you know, I think that these things are linked in that sense. But there are also very different doctrines involved, some of the different kinds of things.
And did Scrimeti change equal protection analysis by basically going back to an old doctrine from pregnancy planning?
Certainly didn't help us.
Questions?
There's a question over there.
I do have a question on my name is Peter.
Let me give you the mic so everybody can hear you.
Hi, thank you for this talk. It's very informative. And my question is in regards to the religious aspect of it, that I think that it's one of the reasons why this ban on transgender people. And what are your thoughts on it? And what is the kind of like the vision for the future in regards to this? Because I believe that it's some that this ban on trans people, it's because of the perhaps the relevance that they may have in religion or in spirituality. And so maybe that's why they're being banned, and even though it's only 1% of the people. If anybody has any thoughts.
I can jump in. I mean, I think certainly there is some, in some set of the court's recent opinions have kind of validated, you know, religious perspectives in a desire to kind of exclude LGBT folks in general. So the Mahmoud decision, there was also another case recently, as you know, the Shadow Docket, California, near LGBT Bonta, expanded Mahmoud. And the court just took a case out of Colorado for religious daycare wanting to discriminate against LGBTQ people. I think we can see where that one will go. That being said, I think that the cultural backlash is much bigger than religion, and that in some ways, you know, it isn't a story of religion versus trans people. I think it's a story of there being just a lot of fear around trans people, and there just aren't that many trans people. And so I think it's harder to have a world in which people are out and are then better understood. And, you know, BPJ is an example of that. Our client, Becky, is the only out trans athlete in the state of West Virginia. West Virginia passed categorical ban of trans kids in sports based on her. So that just is a world of fear and misunderstanding. And I think perhaps that's easier to counter at a cultural level than if it was just solely tied to the dominant religious group. I think that's part of the issue, but unfortunately, or maybe fortunately, I think it's bigger.
Other question? One more.
This is slightly non-legal, but I think when you were introducing some of the past history, you described that when bad events happened, there was a retrenchment of the movement to kind of collaborate, coordinate, push back. And that also seemed to be an important feature of the movement through state courts in the 80s and 90s, and progressively the federal court and the Supreme Court for marriage equality. And for the most part, my understanding of that is that the movement lawyers who were coordinating that strategy were able to dissuade parties who were not aligned with that from filing cases or pursuing them, or were able to roll up those cases their own to make sure they were presented. And what is the sort of status quo of movement lawyering today? I know that in general, the media environment is fragmented. Is that something that the movement is dealing with as well? And holding people together and developing strategy like changes to strategy.
Yeah, I mean, I think that's a great question and movement, I mean, I'm happy to answer the question related to movement wear, but I also think that what I also was referring to during that time period, post Bowers versus Hardwick, of that devastating decision that was issued to the women's country, is that it arguably did result in extreme organizing of the, I mean, not just lawyers, but just community groups, community activists, educators, like people in civic society, organizing and doing a great deal of work to make sure that people were educated about people. And I agree with Pam that much of that progress happened because between the periods that we are talking about, the 40s and 60s, and then into the 90s and even the late 80s, it was no longer true that people didn't know that they could gay people, and that great movement of people coming out and having the safety and security in this country to do that, or just feeling like they had no other choice, really did translate into extreme social progress, which often predates court progress in this country by many years. And so it is not until I think that that social part, the Supreme Court is not made up of trailblazers. And so I think there is this intertwined deep importance between social and cultural and educational progress, and then what you see happens in the courts.
Maybe Gen Z will see the world differently than we do. So on that note, thanks to our guests.
Thanks again, everyone, for being here. And those of you who are here in person, please join us outside for a reception and hopefully have a chance to chat with the panelists then as well. Thanks again.